as to what evidence that may have been presented. After the trial is over, the notes will be destroyed and they will be collected and destroyed. And at this time, please write your name on the front sheet of paper in the pad and make no further notes on the front sheet. That way, no other person can see your notes if your pad should be seen by another person. The law requires that you decide this case solely on evidence presented in this courtroom. This means that during the trial, you must not conduct any independent research about this case, the matters in the case, or any individuals in the case. In other words, you should search the internet, websites or blogs, or use any other electronic tools to obtain information about this case or to help you decide the case. Please do not try to find out information from any source outside of the confines of the courtroom, to include media of any sort or online research. The bailiffs have been instructed to collect your cell phones, tablets, and laptops during the proceedings. You may want to leave those in your vehicle. If they collect them, they'll be sure to give them back to you at the end of the day and on breaks as well. Until you retire to deliberate, you may not discuss this case with anyone, even your fellow jurors. After you retire to deliberate, you may begin discussing the case with your fellow jurors, but you cannot discuss the case with anyone else until you have returned a verdict and the case is at an end. I hope that for all of you, this case is interesting and noteworthy. I know that many of you use tools or technology in your daily life, but you may not do so in connection with your service as a juror. You also must not talk to anyone about this case or use electronic tools to communicate with anyone about the case. This includes your family members and friends. You may not communicate with anyone about the case or your jury service via internet, text messaging, email, Twitter, Instagram, a Snapchat, and on and on and on. You cannot use any social networking websites to communicate anything about this case. I cannot stress strongly enough that communication via electronic devices is prohibited. So at this time, you may see in any of the seats in the trial. During the voir dire process, we ask that you sit in specific seats for identification purposes. However, there is no need to do so during the trial itself. If you need anything while in the jury room, you may knock at the door to notify the bailiff that you wish to communicate with the court. I would then give you instructions on how this should be done, depending on the stage of the trial and the nature of the request. So I'm going to give you an overview of the criminal law and trial procedure that will apply in this case to give you a framework. A crime is a violation of a statute of this state in which there shall be a union or joint operation of act and intention. That is, a crime is committed when a person violates a statute of this state by acting as prohibited, while at the same time he has a criminal intention and no other defense excuses the conduct. A person will not be presumed to act with criminal intention. However, the jury may find such intention upon the consideration of words, conduct, demeanor, motive, and all other circumstances connected with the act for which the accused is prosecuted. The state cannot bring a person accused of a felony to trial unless the grand jury has first indicted that person. Grand jurors do not try criminal cases. They ordinarily only hear from witnesses for the state. When a criminal case is tried, the defendant has pled not guilty to the indictment. This plea of not guilty denies every essential allegation of the indictment and forms the issue or the question that you as a trial jury will decide. The indictment and the plea of not guilty to it are not evidence, and you should not consider them as evidence.